SJC-11990, Commonwealth v. Donald Gibson.
Thank you. Good morning, Ms. McVitie.
Good morning. May it please the court. I represent Donald Gibson. Mr. Gibson had a violation of probation hearing. He had several counsel appointed to him.
Correct, for the violation of probation hearing. 3 counsel were appointed,
3 counsel were appointed, Your Honor.
and they were all rejected in some fashion.
Well, the first counsel was his counsel from September to March, and then he was appointed another counsel who sought to withdraw.
Why did the first counsel get out, or why was there a need for a second counsel?
There was a breakdown in the attorney-client relationship for the first counsel and for the second counsel. When the third counsel was appointed by the court basically said, you know, she had read the affidavit and this is your last counsel. And I think that there is an exhibit in the Commonwealth's appendix number 61, where it's clear that Mr. Gibson wasn't aware what was in the prior attorney's affidavit.
But he was aware that the court advised him that this is it, this is your last lawyer.
Yes.
And then what happened to the third counsel?
The third counsel, he had a problem with during the summer, and he asked that the counsel be withdrawn.
But your client had a problem with the third counsel as well.
Yes, he did.
Okay, so the counsel withdrew.
So the counsel withdrew, but he withdrew as primary counsel, but he was kept on as
Standby?
Standby counsel.
And that's how the proceeding proceeded, or was there something else happened after that?
And after that, there was a problem with that counsel.
So another problem with the same counsel, acting as standby.
Correct.
Okay.
Mr. Gibson, I think that when you read the transcripts, he has a particular point of view. He has mental health issues.
Could I just ask you on that point? There was one point, I think, in the last hearing, maybe the last or the penultimate one, where he said something about a brain tumor.
Yes.
Was that ever investigated, or are there any medical records in the record, our record, about that, or did that go anywhere?
Wasn't there a request for funds, and that was denied, and it was $30 to get a copy?
Yes, there was
of the medical records, and that was denied.
It was denied, and he had medical records at the probation hearing. He wasn't allowed to submit them at the beginning of the hearing, and then when the hearing was over, he wasn't allowed to submit them.
This is before Judge Carey?
Yes.
Okay,
Yes.
but back at the point in time when we're talking about, before Judge Kinder, was there nothing happened with that?
Nothing happened, and I do want to talk about that hearing and the way that hearing came about, because there was one day between being told that there was a show cause order was issued, and then there was the hearing, and the attorney who was representing Mr. Gibson at the hearing was clear there were mental health issues. This man needed an examination, and that was denied. Under means, when the court talks about the totality of the circumstances, how do you get to the totality of circumstances when you are appointed to someone? There's 1 hour, and that's in the transcript, there's 1 hour, you can't get through, this person obviously has mental health issues, you go to say to the court, this man needs an examination, and perhaps, and I think that his recommendation was excellent, that someone from the mental health panel could better deal with this client.
Did the judge know about all of the other evaluations that had taken place? Is this a case where he had been evaluated many times before?
He had.
And nothing was found to be problematic? He got another lawyer and the same thing happened. Was the judge aware of this history?
The judge was aware, the judge looked at the docket sheet, and he was aware, because he talks about the procedural history, but there's nothing in this record that would show that that Judge Kinder actually went back and looked at the evaluations, because someone can be found competent but still have mental illness that interferes with their ability to work with an attorney. It's a matter of degree, and there's nothing that shows that he had looked into those evaluations. Now, there's an evaluation, but just at the forfeiture hearing, he didn't have that. He determined from the bench that Mr. Gibson seemed lucid and somewhat articulate, but that...
Well, let's go through that hearing. This is the hearing before Judge Kinder?
Yes.
Okay. So the prosecutor tells Judge Kinder that the defendant has been evaluated twice before for competency, been found to be competent. Attorney Dunphy is present for this hearing as well?
Yes, he's...
And what does Attorney Dunphy testify as to the defendant's competency?
He basically testified that he wasn't aware of a mental illness, but Mr. Gibson wasn't logical and didn't follow.
I thought he said he was lucid, responsive, and able to articulate his position with clarity.
Wasn't that Judge Kinder?
That was Judge Kinder.
That wasn't the... Okay, so I'm sorry. Dunphy said what?
Attorney Dunphy basically said that, you know, what he asked for, and you know, he gave advice, and the client didn't take it, and his position wasn't logical. There wasn't a lot to that hearing.
And then the attorney who was appointed for the forfeiture hearing, whose name I'm blocking on right now.
I'm sorry, I can't think of his name right this second, but he...
But he also...
Franco.
I knew it was an F. He also talked about mental status, didn't he?
Yes, he was asking the judge for this defendant to have a mental health evaluation, not just a competency evaluation, but a mental health evaluation. This was someone who had difficulty working with attorneys, because I think if when you read through the probation hearing, he clearly has a viewpoint that is most attorneys would not be able to put forth in a violation of probation hearing, I think would be the best way for me to phrase this. And so it makes it very difficult, yet the court can find someone competent, but they still can be mentally ill.
So what do you do about that? He's competent. He won't cooperate with any lawyers. He's had 8 lawyers in the course of the legal proceedings, none of whom he's cooperated with. So what is a court to do?
I think that the suggestion of Attorney Franco of having a mental health attorney working with someone like Mr. Gibson, because...
There was one attorney during the course of the trial that actually concluded the trial, right?
Yeah, the trial...
So let me go back to, if we could shift for a minute, to, are you suggesting that the means test used here was too broad? Is that your argument, that really wasn't adhered to in this case? This wasn't a proper forfeiture, because the judge was looking, as I understand it, looking to something that happened 7 years before.
Absolutely. When you look at the means test and you look at, you know, a physical threat, there was one affidavit where apparently Mr. Gibson told him that something about street justice. That was in 2007.
So was that before trial?
It was before the trial. His right to an attorney was not forfeited at that point.
And it didn't involve this attorney.
Not at all, or this proceeding.
Do you think, given the history, the three, or the four and then the three, it seems to me that there is some merit to the suggestion that this could be forfeiture by conduct.
It's waiver by
Excuse me,
conduct.
waiver by conduct, sorry.
Forfeiture or
Sorry,
waiver by
I'm
conduct.
mixing it up. I mean waiver by conduct, yes.
Waiver by conduct involves, in this case, there were no Faretta warnings, and
But is that the one, I mean, but given the number of attorneys and the repeated message, I agree with you that there's no indication that Judge Page or anybody else gave the appropriate warnings. But in terms of, put the judge aside for 1 minute, just in terms of the conduct of the defendant.
I think it's so case-specific. I think in this case, when you have clients who clearly have mental health issues, they're difficult clients, yes, their conduct is difficult. But those people need representation, sometimes more than others. This wasn't someone who, I mean, you have clients who are just totally disrespectful, and they think, 3 or 4 attorneys I can see, the court might not give them another attorney, but
But let me
What
play
was the
devil's.
conduct here that was warned of? Isn't that what was required in waiver by conduct? So the judge has to warn the defendant, this is what you're doing, so stop doing it. Did that happen here?
that didn't happen here. Basically, what Judge Page said is, I've read the affidavit of your prior attorney, and you're not getting another attorney after this one. And then he writes to his attorney, he wants to know what the affidavit says. So he clearly didn't have the affidavit, well, from the record, he didn't have the affidavit that told of the conduct that upset Judge Page, that informed Judge Page, saying no further attorneys.
Did we know who the prior attorney's affidavit was that was referring to? Because there were several by that point.
I
several females
thought
that
that
said
it was
her.
Attorney Whitney's.
So
'cause
it's
it was-
it's one that we
no.
have, in other words.
Yes, it's the one that you have. And
Did he know which one was being referenced?
he wouldn't. But I think another factor that the court, I would hope the court would look at, is what, there's a difference between a violation of, a misdemeanor and what the consequences are of going through a violation of probation hearing without an attorney. And then, in this case, he was looking at up to 10 years. I mean, this was a severe consequence.
Could you answer for me, if he's found competent, why doesn't that resolve the question of being able to cooperate with your attorney? I mean, you said that you could be competent and there could be mental health issues, but I'm assuming that when you have a competency evaluation, part of that or most of that is your ability to understand the proceedings and to cooperate with your attorney. So how would the mental illness come in to negate that finding?
Well, actually, most of you are more than aware than I am that in Superior Court, they have a competency hearing, and it's not a competency evaluation that, just like at the probation hearing, in this case, part of the record, that he talked to the psychologist. They have, an hour, whatever. It's not
When was the last competency examination before this hearing? Was there one at the time or recent?
The prior competency hearing was at sentencing. Mr. Gibson slit his throat when he was found guilty, and then there was a competency hearing after he was sentenced, but there was also a competency hearing before the trial.
Okay, so there wasn't a recent finding of competency at the time that this forfeiture was effected.
No, and the fact that Mr. Gibson can work with some attorneys and did work with some attorneys, didn't work with the other attorneys.
Well, he worked with
mental
one,
ill-
right? He worked with one. We know he worked with one because he got through the trial.
He got through the trial, he got an appeal, and he still has an appellate attorney.
Okay,
So
good point.
he,
But not the original appellate attorney? No? Same appellate attorney?
I'm,
You,
You? I don't know, but was there someone
Qualify
before
for
you?
sainthood,
well,
don't
the
you?
original appeal of the underlying case,
Right.
he had an attorney, granted, oh, my
Yes.
time is up, but granted, we can do Moffett briefs, but I would ask the court not, because I know you're looking at how many attorneys can someone have, and I would ask the court not to have any bright line, because each of these cases are different, the clients are different. What creates the break in the attorney-client relationship is different, and also, at any particular time, someone can change. To use something from 2007 against someone in 2012,
Well, when was the competency hearing at sentencing? What was the date of that?
the date of that would have been August of 2000 and, I have it written down, 2008, August 21st, 2008.
So that had been the most recent competency hearing, and that was at his sentencing, which was in 2008.
2008.
And the probation revocation was when?
The probation revocation
2012.
was in, he was arraigned in September of 2011,
wasn't it 2012 when it finally happened?
and 2013 is when the probation violation hearing in April of 2013.
And was there not another competency hearing done in 2013 by the judge? I thought Judge Kinder had ordered that, no?
He didn't know.
So basically, he was relying upon the August 21, 2008 evaluation?
Yes,
And that was in the context of having counsel.
yes.
What is there a difference between being competent to assist your counsel versus being competent to represent yourself?
I think that assisting counsel is, if you cannot assist counsel, if you cannot do that, and let me articulate
I
this
mean,
better.
certainly if you can't assist counsel, you can't do it yourself, I think.
Can't do it
But if you
yourself.
can assist counsel, does that mean you inherently can do it yourself, or can?
I don't believe so, Your Honor, because
That's not a question. Is there cases that talk about that? Do you know of any? I mean, it's an interesting question. I just don't know.
well, there is a Supreme Court case that states that this man was found competent, but he wasn't competent to be pro se. And I believe I have it in my brief, but I can't think of the name right offhand. But that is, the Supreme Court has not really weighed in on this issue, other than to say if you don't show up, you lose counsel. If you're so, create such a ruckus and, you can be removed from the courtroom. But there is a case where the court says that you can be found competent to stand trial, but not competent to conduct a trial pro se.
Okay, thank you.
Thank you, Your Honor.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Bethany Lynch, representing the Commonwealth. In this case, Judge Kinder appropriately found that this defendant, this particular defendant, forfeited his right to counsel in this case. And just if I could back up to one last question, there was a fourth competency examination conducted on this defendant.
A fourth? We
A
were just
fourth.
talking about two. Now there's a third
There's-
and
there
a
are
fourth?
There were 4 total from his original trial date through the
Okay.
probation violation hearing. I can give you the 4 dates if you like, but the most recent one was on April 10th, 2013, which was after the forfeiture proceeding, but prior to the violation of probation hearing itself. So it was Judge Carey by that point, and he did order, I believe it was Judge Carey, he did order a competency examination prior to the defendant actually conducting.
But
and
Judge
being-
Kinder, that obviously was
Judge
after
Kinder
Judge
did not.
Kinder.
And Judge Kinder was aware that the prosecutor at that point said he had had 2 prior competency examinations. In actuality, it was 3 prior.
But what was the one that was the most recent to the?
The most recent was the August 2008,
So
the
there
one
was
right at
still
sentencing.
So that was.
There is still a gap,
Okay.
yes. But I did want to highlight that there was yet another competency before the actual probation violation hearing.
Didn't play into just Judge Kinder's
It did
decision
not.
at all.
He found that in his, I don't want to say examination, in his interactions with the defendant, he found him to be lucid. He found him to be definitely on point. He definitely was a very strong personality. I think that will come through in all of the reading that you do on this case. But this defendant was unable to get along. It wasn't even just that he was unable to get along with his attorneys. He was.
He'd get along with his
He
trial
did get
counsel.
along with several. He got along with one trial counsel after having had, I believe, 6 prior to that, and having been warned that he would lose his right to counsel if he continued
That
to
the one
be
that
unable.
was appointed at the time that Judge Page gave him the warning?
Judge Page actually warned him on two occasions, and throughout, if you consider the case as a whole, she warned him initially. He was appointed an attorney for arraignment purposes. He was then appointed an attorney Dickerson. She withdrew because the defendant accused her of conspiring with the district attorney. This was all well before trial.
But did he ever have the same lawyer for the violation of probation
No.
proceeding as he had at trial?
No, his trial counsel withdrew, his direct appeal took place, and then
Have the
following
lawyer
that-
for the appeal?
He had an attorney for the
So
appeal,
he
yes.
got along with the trial lawyer and the appellate lawyer?
I presume he did. I didn't hear any complaints, I
Yeah,
guess I
the
should
trial
say.
lawyer didn't withdraw because
He
of a
did not.
problem, but because that's just the procedure that you do.
He
You
did not.
withdraw so the appellate attorney can be appointed.
Exactly, he withdrew, right, yeah, and I'm not, yes, I do not count him as an attorney that he had a problem with. But the attorneys that he did have problems with, he accused of conspiring with the prosecution. He accused them of unethical conduct. He threatened to report them to the BBO. He threatened to sue them personally. And on one occasion, he did threaten Attorney Bernard O'Connor. He threatened him with physical violence.
And that was 2007.
That was in 2007. And Judge Kinder, I don't think that Judge Kinder should be precluded from considering the entirety of this case. Because while this defendant,
I mean, this goes beyond means. I mean, means was forfeiture by acts of violence or threats of
Yes,
violence.
yes.
So are you arguing that forfeiture and means distinguishes between waiver by conduct,
yes,
which requires a colloquy? Are you contending here that there was waiver by conduct, that the colloquy by
Page,
Judge Page was sufficient to support a finding of waiver by conduct?
my primary argument is that this was a forfeiture of his attorney.
So then that would mean we'd have to go beyond the standard of forfeiture established in means.
The only way you would need to go beyond that would be if you were to definitively say that in the absence of an act or threat of physical violence against the attorney, the defendant cannot forfeit his right to counsel. In this case, under means, there are four guidelines in means. The first being that he had more than one appointed counsel. Clearly, we can check that box. The proceeding was something other than a trial. And in this case, it was a violation of probation hearing, which would arguably be part of the sentencing portion, not a separate trial where the defendant is faced with a beyond the reasonable doubt burden that needs to be proven. The third is threats or acts of physical violence versus counsel, or of violence versus counsel. And the third is grave and deliberate misconduct. I'm sorry, the fourth is grave and deliberate misconduct. In this case, I would argue that the only thing that we may be missing is an act of or a threat of actual physical violence And that is if you don't count his trial counsel, because he did threaten one of his trial attorneys with physical violence. If you don't count that, if you were to limit your consideration, and I would suggest that you shouldn't because it gives you a false impression of the overall story in this case, but were you to consider only the probation violation attorneys, we'll call them, in those cases, the defendant did not admittedly threaten any of them with physical violence, but he did threaten them in different ways. The first attorney was Attorney Baker, and he withdrew due to the defendant's combative attitude, threats to report him to the BBO if he does not adopt the defendant's strategies, and the defendant said he wanted a new attorney.
But
And I
it
believe you
isn't,
have that.
I mean, if we say that you get forfeiture because a criminal defendant threatens his lawyer with going to the BBO, we are in deep trouble.
Well, I would agree, which is why I'm saying in this case, this is a lengthy pattern of conduct. If the attorney did not do what this defendant wanted him to do, the defendant would accuse him of misconduct and accuse him of unethical conduct. And at least in the case of Attorney Dunphy.
Okay, so we got one down. Now let's go to the second attorney.
The second attorney said that she had a breakdown of the attorney-client relationship with the defendant and was allowed to withdraw. And after that withdrawal, that is when Judge Page said, I've looked at the affidavit and you will not get another attorney appointed to represent you. This is all under the probation violation proceeding. And the defendant said, well, if they won't work with me, then I can't keep them on. And the judge said, you're not going to get another attorney after this. And the defendant indicated that he understood that.
What if,
What happened to the third attorney?
The third attorney, Attorney Dunphy, the defendant moved to remove him, claiming that Attorney Dunphy was senile and he lacked any confidence in his abilities. He's not listening to me. So Attorney Dunphy originally indicated he thought he could work with the defendant, but he was then placed as standby counsel. After that, then Attorney Dunphy came forward and said, I cannot work with him even as standby counsel. He's now threatening me with lawsuits and with reporting me to the Attorney General, with lawsuits, with complaints to the BBO, and he's insisting that I use the private investigator that he received funds for in order to contact the victim on behalf of the defendant. So he was asking his attorney to be a conduit to further violate his probation, in essence. And I know that the mental competency is an issue that was discussed earlier, and I would suggest that there's very little indication of mental illness in this case. This defendant is highly manipulative, and he threatens people when he doesn't get his way. And I would suggest that that's the only real evidence that we have, if it's evidence at all, of any kind of mental incapacity. He was evaluated 4 separate times and found to be competent. And his manipulation, I would say, argues against the fact that, or the claim that he has some mental incapacity that would preclude him from being able to represent himself. He is trying to manipulate his attorney, and when he doesn't get his way, he will threaten them with any number of things. And I would suggest that in this case, the defendant, I'm sorry.
Go ahead.
No,
finish.
If it's not a forfeiture, then I would suggest that it was a waiver by conduct. The problem with the waiver by conduct, obviously, is that there was no full colloquy. In this case, this defendant, however, I would suggest can, based on the Pamplona case, which is an appeals court case, that his waiver can be based on his background, experience, conduct, circumstances of the case, and the fact that this defendant has a multitude of prior convictions. He has experience in the criminal justice system. He's been through any number of attorneys. He clearly knows the importance or the advantages of having an attorney. He was warned to work with his counsel, and he was unable to do that, and he kept threatening and just to try and get another attorney. He was able to draw out his probation violation hearing for nearly 2 years.
That's what I was going to ask. So he's on probation November of 2010, immediately begins violating
Yes.
the terms of his probation and does all the way through.
Yeah, and he violates right up
2012.
through
Yeah, through 2012, in any event, maybe even 2013.
2013, yes.
So what's his status during this period of time? Is he incarcerated?
Incarcerated. He was convicted of 2 counts of indecent assault and battery on his daughter. He was sentenced to 8 to 10 years in state prison from and after a sentence he was serving on an unrelated matter. His probation on count 2 was set to run concurrently with his incarceration, primarily because of the no contact provision.
I see. So he was actually incarcerated,
Yes,
serving this
while
other
on
sentence.
probation, yes.
And basically succeeded in kicking his violation hearing off
Yes,
2+
for
years.
2 years.
And what was
And-
the sentence after probation, by the way?
After he was
Yeah.
found in violation, he
Right.
received a 7 to 10 year sentence on and after the original, on and after count 1.
You can do that?
Sorry, this was after probation violation, it was 7 to 8 years, I thought.
I'm sorry, what did I say? It was 7 to 8. I'm
7 to
sorry.
8. What do we do? I mean, this is the type of case that try judges' souls. So I understand the predicament, but there's also the predicament of somebody facing a probation revocation hearing where he indeed did get 7 and 8 years on and after,
He did.
where there may be serious issues about whether he was competent to represent himself, even if he were competent in the traditional way of being able to assist counsel.
Well, I think that
What do we
that
do with
is-
that?
I think that that is the issue, is that this defendant was so difficult, and to just kind of baldly state that he was not competent to represent himself, there's really nothing to support that. He was found
Because, but
competent.
he asked for $30 to get, because he did
Yes.
baldly state, I have a brain tumor, I have a problem, it's beyond competence to assist someone, there's something going on here you need to know about. $30 will get you that information. So,
And the judge
What's he gonna
declined to give
do?
him that $30 because it was on the eve of the probation violation hearing, and because he agreed, because the results of those tests or the medical records were in his jail medical records, and the judge said it's a probation violation hearing, I will take those. I will take those as evidence, so I will consider that. And he did argue that. He argued that he had some
thought they weren't legible.
brain issue. I'm sorry?
And they were legible and they could talk,
I haven't seen them, I don't know.
Were the jail records admitted in evidence?
I know they were referenced numerous times. I don't know
I mean, but isn't
That they
that
were-
sort of a problem if you have
that they were referenced.
the
Well, I
judge
mean, I
says, I
think
will
that that
consider
would
them if
be-
you offer them, and then as far as we know, they're never offered. We don't know what they say. We don't know whether they would
Don't know.
support or not. But that's, I mean, that's the concern that one
It
has.
is, but that would
when-
always be a concern when when a defendant is proceeding pro se. This defendant, maybe he made a legal error and did not know to offer them, but that is the downside of proceeding pro se, and the pro se defendant is held to the same standards. We don't give him a benefit just because he's pro se. If he
But
made
the
a
problem
mistake,
is
I
when
understand.
when the self-represented person says, I have a brain tumor, which is affecting my ability, and we don't know whether that is true or not.
I don't know if that's true or not. I do know that he argued it to the judge. I do know that the judge had infinite patience with him, and that the brain tumor.
Carey, or
It was Judge
who?
Carey, yes. And
The two-day proceeding.
it was a two-day
It
proceeding.
was preceded by, as you have pointed out, by yet another competency
Yes, a fourth
examination,
competency.
in which he was found to be rational, have meaningfully understood the nature of the probation proceedings, had a strategy for his defense, and was competent to go forward.
Yes, and in reading the probation violation proceeding itself, he doesn't do a bad job. I mean, I don't know if that's something that for you to really consider that closely, but he does cross-examine. He did have a defense that he offered, was that the terms of the probation, the conditions of probation form, he never signed initially, and there was a variance between the form and between what the judge actually ordered. He introduced that. He cross-examined the probation officers on this point. At the sentencing portion, this came down to a very discrete issue. And so I think I would also like to highlight that I'm not sure how much more a defense attorney could have done for him beyond what he did for himself in this case. His issue was, did he contact the victim? And he acknowledged that he did. On 5 separate occasions, he sent them letters. That's the probation violation. No, I don't know what an attorney would have done any differently that would have benefited him more. He had 2 years through multiple attorneys to prepare for this, nearly 2 years, to prepare for this hearing. And he cross-examined witnesses. He was cut off from cross-examining his daughter, who was the victim, because he was going down some avenues that were not relevant.
How old was the daughter at the time of the probation violation hearing? Ballpark.
I think she was in her late teens. She was under 14 at the time of the original trial. I'm sorry, I don't recall her actual age, but she wasn't a child. But she did, and he did also argue for concurrent sentencing at the end when he was asked for a sentencing recommendation from Judge Carey. So in this case, I think if you look at these facts and the number of attorneys and the number of varying threats that he made to them, whether or not they were of physical violence, I would suggest that this is a case, one of the rare cases, as Judge Kinder stated, that forfeiture of his counsel was an appropriate decision in this case.
All right.
Thank you.
Thank you.
Thank you.